Good afternoon. You can be seated. The matter before the court is BCD 24-318, Olson versus Gleichman et al. We are being streamed live on the web, and that is both by audio and by video. And before we begin, if counsel would identify themselves by saying their names for the record, together with the party you represent, starting with the appellants.
And Pam Gleichman and Carl Norberg, as well as the Ellen Hancock, as trustee of the Hillman Norberg Trust.
Good afternoon, Your Honor. Gerald Petroselli for the plaintiff appellee, Richard Olson, trustee of the Promenade Trust.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. I represent, as I said, Pam Gleichman and Carl Norberg, and the trust, which is a trust for the benefit of their son, Hillman Norberg. They were the grantors of the Promenade Trust back in 1988. They set it up for their children, and they were the only persons who ever contributed anything to the Promenade Trust. And yet, here they are being sued by the Promenade Trust, as well as a suit being brought against the trust that they subsequently set up in 2012 for their youngest son, Hillman. And the action is an action to take back some general partner interests that Pam Gleichman owned in one of her many partnerships. She had, at that time, about 50 partnerships, and she had to, because of economic circumstances involving her daughters taking over management of the management companies and causing liquidity problems, she had to transfer the general partner interests into a trust for her son, Hillman. And those were just 3 of the 50 trusts. The other 47 trusts are in the Promenade Trust. So the Promenade Trust is here seeking the last 3 out of 50 general partner interests. And the interests were conveyed to the Hillman Trust well before the interests went to the Promenade Trust, which was in 2018. The transfer to the Hillman Trust was in 2012, and it was undertaken with the knowledge and the assistance and involvement of the trustee of the Promenade Trust, who was Chris Coggeshall at that time, a family trusted lawyer from Verrill and Dana. And so the goal of the transaction was entirely legitimate. It was to save the family home in Bar Harbor, which a bank was foreclosing on. And the idea was to pay off that creditor with monies and the pledge of this new trust, including the personal guarantee of the trustee of the new trust, who was Ellen Hancock, who has since died, but she was a very prosperous and successful woman whose guarantee was worth a lot of money. And so the plan was to get her involved and get the interests with the involvement of the interests, the distributional interests from these 3 projects, and her involvement would get the house refinanced. So it's all very above board.
I see the green light is on.
Huh?
There's discussion and reference throughout the record here to the fact that the HN Trust, the Hillman Trust, was defective in some way. Can you shed some light on that? What was the defect, and what was the legal, if any, consequence of that defect?
I don't think there's any legal consequence. There was an opinion from an Illinois lawyer that it could not take in additional assets other than the initial assets. So instead of just amending it to say it can, when they went ahead to put some other assets, when they bought some other assets, they put it into a separate trust. So it's nothing more than...
What was the defect?
The defect was supposedly some language which said which didn't call for adding additional items into the trust. So it's, the initial items were added into the trust, the GP interests, which are right there in black and white. In the trust itself, it says Pam Gleichman is giving her interest in these 3 projects. The idea was that if she wanted to add other interests, she couldn't.
Well, I thought it referenced that, but in any event, the trial court found that there was no evidence of a conveyance. The trust here does say, as you just pointed out, in the very first paragraph, that I transfer my interest in these properties. Is your position that's sufficient for purposes of conveying that interest?
Yes. I mean,
So is the trial court clearly erroneous?
Yes. I mean, it was clearly, it clearly did contemplate, it was an agreement between the transferor and the transferee that these interests go into this trust, the Hillman Trust, and the document is not a separate deed, but it's right there in black and white. It says, Pam Gleichman, hereby convey the interests that are in Exhibit A to this document. So the trust document served as establishing the trust as well as the conveyance document.
Well, if that was true, then why wouldn't the HN Trust had to have transferred the partnerships to the HMAN Trust?
Well, there was never any need to do that.
But I thought you said the transfer did take place from Gleichman to the HN Trust.
From Gleichman to the HN Trust, it did take place.
So if the transfer took place to the HN Trust, then the partnership interests were with the HN Trust. Wouldn't the HN Trust have to have been involved in a transfer of the partnership interests to the HMN Trust?
If there was a need to close with the refinance entity, perhaps, but in fact, there never was a closing with they were not unsuccessful.
But the closing, isn't the closing unrelated to the transfer?
Well, the transfer occurred in
Right.
2012. I mean, the buyer and the seller both say it had occurred, and that nobody ever contested.
So mine's a simple question. At some point in this litigation, you're taking the position that the general partnership interests were transferred to the HMAN Trust, correct?
No, they are in the HN Trust. They remain. I mean, the party here is the HN Trust, and that's who was sued, is the HN Trust.
Can I ask a question about the counterclaim? I mean, you're asserting on appeal that it was improper to dismiss the counterclaim. But my understanding on the counterclaim is, although it had different denominations of theories, whether seeking to impose, constructive trust, fraudulent inducement, unjust enrichment, et cetera, nonetheless, my understanding is that all of the claims relate to the extent, however many pages it goes on for, relates to the administration of the trust, the Promenade Trust, correct? By Olson.
They relate to the representations made by the trust in regard to, basically, the gist of it is that Chris Cogshaw, as trustee, said to Carl Norberg that if you provide us...
I understand.
You know that, all right. So
but my point is that they all relate to actions as trustee.
As trustee, yes.
And my understanding is that none of these named defendants are beneficiaries of the Promenade Trust. Is that correct?
None of the...
Named defendants, i.e. the claimants on the counterclaim, are beneficiaries of the Promenade Trust, correct?
Well, they're not the beneficiaries. The current trustee or the trust.
They were the settlors of the trust, correct?
No, my clients were the settlers.
Correct.
And the action is based on promises and representations made to them.
But here's what I'm getting at. If your clients are the settlers and not the beneficiaries, and the claims are relating to the administration of the trust, how can there possibly be any standing to assert those claims?
Well, I think my contention is that trusts can make representations to third parties, and have liability. And I think I've cited sections of the Maine Trust Code that say there is liability, and there is a split in the courts between whether a trust is an entity or is a fiduciary relationship, I guess.
Counsel, can I put a slightly different spin on that question of the Chief's? Are any of the counterclaims that are being asserted here, are any of them unrelated to the duties of Mr. Olson as trustee. He was sued individually, but those claims have been dispensed with. So we're talking only about Olson acting as trustee. Are any of the counterclaims here unrelated to his duties as trustee of the Promenade Trust? And if so, which ones?
I don't think they're unrelated. My theory is that he took over the position of controlling this corpus.
He didn't make those initial representations. He wasn't involved in that.
No, he
Coggeshall
didn't.
was.
I agree.
So he steps into a position now of fiduciary responsibility to beneficiaries, right?
Yes.
Is he to disregard that?
Well, no, he's supposed to, the beneficiaries were receiving very important rights as a result of an agreement made by a prior trustee. So my theory is that the entity that it is should be treated like a corporation or an entity, and there is a split in the law.
Regardless if it's an entity or not, we're still talking about a trustee's fiduciary obligations to the beneficiaries.
Yes.
And my question is, are any of the counterclaims that you're opposing here unrelated to the trustee of Promenade Trusts, to his duties, his fiduciary duties to the beneficiaries of the Promenade Trust?
Well, I think they're unrelated in a certain sense.
Which ones?
Well, they're based upon promises that were made. I suppose they're related. They are related in the sense that the trust received valuable assets as a result of promises made by a prior trustee. So,
You know, some of those assets were judgment liens that the trustee was now trying to acquire.
and that he acquired them with conditions on them, that they would not be used adversely to...
Then what value are they?
Well, because it was a family effort. The whole thing was a family effort. This was not a creditor coming down on this.
Well, we
This
can
was-
all agree this is not a family that is singing Kumbaya around the fireplace.
But they were at the time that this transaction happened. They had Chris Coggeshall.
Why isn't Coggeshall then a party to this case? He's the one who made the agreements, not Olson. Olson steps into the shoes of the trustee. He steps into the duties of fiduciary duties that position entails with respect to the beneficiaries of the trust.
Well, I would suggest that in terms of, if it were analogous to a corporation, you would look to what prior agents of the corporation had committed the corporation to.
This is not a
If you
corporation.
ignore
It's not a corporation.
I know it's
That's
not.
the point.
But if it's-
I mean, take your situation. If you had a partner in a law firm who made certain representations to a client or took certain actions, and then you step in to take over, you have a duty to the client or to other clients. Are you going to disregard your duty to the clients in favor of what your partner had done?
I'm going to tell my clients that there were commitments made by our entity prior to my taking over, and I have to honor those, or else...
Even if they're contrary to the beneficiary's interest?
Well, I don't think they are contrary.
Well, yes, but
that's a
you
factual...
may not think so.
That's a factual matter, actually. Was it? But I believe Chris Coggeshall will provide compelling testimony that it was a family effort to protect Pam and Carl and the whole family, not to protect one element or one child or another child. It was a family effort. He testified to it. That's in the record. So I believe that all the allegations have been set forth in regard to each count of the counterclaim. I believe the jury trial right is quite clear here as well, based upon the U.S. Supreme Court's decision, which was the Supreme Court. Interestingly, the U.S. Constitution was enacted only 30 years before the Maine Constitution. So it's great authority as to the treatment of fraudulent transfer cases back before Maine became a state.
Thank you, counsel.
Thank you.
Attorney Petrucelli.
Thank you, Your Honor. May it please the court. I think I need to begin with the subject of what is evidence and what is not, and what are findings and what are not. I don't believe there is any evidence that Christopher Coggeshall ever made any kind of promise of the sort that's being asserted here. There are allegations, but no findings in this order to the effect that there may have been some hopes or understandings by the settlers of the Promenade Trust, but the idea that the whole arrangement is premised on the proposition that the only reason the judgment liens were transferred to Mr. Coggeshall was because he promised never to use them for anything. In fact, to go back to the beginning, Mr. Norberg had borrowed or misappropriated, depending on details I don't need to get into here, over $4.5 million of Promenade Trust money to buy the bricks for the wall of debt. The wall of debt was avowedly, and I cite in the transcript, not to anything other than the allegations of the counterclaim, that the purpose of this whole scheme was to hinder, delay, and defraud all of Pamela Gleichman's creditors and to prevent any of them from collecting any of their money. And so those bricks for that wall of debt were acquired with Promenade Trust money, and at length Mr. Coggeshall finally prevailed upon Mr. Norberg to make it good, his withdrawal of the $4.5 million. He didn't have the money, so he assigned what he had bought. Mr. Coggeshall retired and resigned, and then transferred all those assets to his successor trustee, who has, as Your Honor was suggesting, fiduciary duty to protect interests. But even today, Mr. Olson is not seeking to enforce today any of those judgments. He is seeking to protect the opportunity years from now, when there are contingent on liquidated potential distributions from 3 partnerships, that money goes not to Pamela Gleichman and not to Mary Wolfson for the sole benefit of Hillman Norberg, but goes per the charging orders that were foreclosed in Illinois to Mr. Olson as the holder of the Norberg liens purchased with Promenade Trust money to close the loop from the original misappropriation. And nothing is going to happen in terms of actually enforcing those liens in the foreseeable future, because until there's a distribution, the charging orders have nothing to latch on to. And so all of this, look over there, look over here, the first place to look is to find whether or not Christopher Coggeshall ever made a promise binding upon Mr. Olson to look the other way and not do his job and protect his beneficiaries. But the essence of protection here is simply to forestall the current effort to hide these assets out of the reach of the charging orders that were foreclosed in Illinois. And by the way, in the Illinois proceedings, Pamela Gleichman put in evidence of her ownership of the general partner position years after the purported transfer of it to Ellen Hancock. Ellen Hancock never acted as a trustee.
You said as for the purported transfer, and as you know, in the trust document, the only language that relates to transfer is Pamela saying, I transfer to my trustee the property described in Schedule A. Is that single sentence there sufficient, adequate, and legally sufficient to transfer ownership of the assets that are purportedly transferred?
No, Your Honor. And first,
why not?
First, because that was basically a preparatory document for a transaction that never happened, and so all the rest of the parts went away. But passing that, all it says is I transfer what's in Schedule A, and as the court found, as a matter of fact and as a matter of law, if I can find it.
Are you going to give me the laundry list of reasons why it didn't look like it after the fact?
You can look it up.
Yeah, I mean, we know them. Bank of America never approved the loan. Hancock never gave a guarantee. Hancock never functioned as a general partner, never filed tax returns. In fact, Pamela did. You're going to give me that list.
Yes, all of that.
And my question to you is simply, if someone creates a document that says, I hereby transfer my interest in these things to a trust, does that make it happen?
I think it depends on other circumstances. The circumstances here are that complex federal regulations and limited partnership agreement documents and financing documents for all of these properties have all kinds of requirements of notices and consents to any material change, because The government, as lender, has a strong
So
interest.
if the consents aren't given, does that nullify it ab initio, that it never got off the ground?
That's one of my many arguments, Your Honor.
Counsel,
Never happened.
can you point in the record specifically to where those consents are required?
Oh, dear. Right now, that will be a bit of a challenge, but I'm sure that
Well,
we have...
I've looked through the Harbor Hill, On the Green, Mallard Pond. I've looked through those limited partnership documents. I couldn't find any requirement with respect to the general partner's interest, not conveying the limited partnership or the assets within that partnership, but I'm talking about the economic interests of a general partner, which are transferable under statute.
I understand.
Correct? Where in those documents or in the record are those consent requirements?
I am confident that someplace there are
You
the...
didn't mention them in your brief.
I don't remember. The regulations, there's complex regulations, and I know that we used them in the depositions, and I thought we had introduced all of that stuff into the trial record. And as you know, the trial record is voluminous because we agreed to put it all in and sort it out later. But there are HUD or rural development regulations about the importance of the general partner having an economic interest in the property in order to be the general partner. And we relied more on the regulations than on the partnership agreements. But the point...
I wish there had been a cite to those regulations.
I apologize,
That would have been
Your Honor.
helpful. But other than that, let's put aside the consents for a moment. Why isn't this document, this is the Hillman-Norberg Trust, October 23, 2012, why isn't that a sufficient evidence of a transfer of an interest?
Because of the overwhelming other evidence.
What other evidence?
All of the behavior of all of the parties for the rest of time until
Okay.
2018.
That may go to a different question. Those are potentially badges of fraud under the Uniform Fraudulent Transfer Act. I agree. Those may not be irrelevant considerations, but do they override an express written document which says, I transfer to my trustee the property described in Schedule A?
If there were no subsequent behaviors to the contrary, perhaps not. If this was a piano or an automobile, perhaps not.
Well, no, that might evidence a fraudulent transfer, but it doesn't negate the transfer,
Well,
does it?
Your Honor, I am more than content to take the judgment on the basis that this is a fraudulent transfer.
In
but
that, in that light, then, is there a valid lien here that would reduce the value of the asset and thereby make this not a transfer under the Uniform Transfers Act? Does the transaction, the creation of the wall of debt, for example, and the Promenade Trust acquiring that interest in the three partnerships, does that literally or technically fit the definition of valid lien in the fraudulent transfer statute?
I don't think I can improve upon Judge Duddy's analysis in the order. This lien does not defeat itself. The lien was bought with money misappropriated from the trust, the Promenade Trust, and it is now owned by the Promenade Trust, and somehow magically in between, it both defeats the Promenade Trust's ability to win a fraudulent transfer case and gets stripped of the opportunity to enforce itself in future time when these distributions occur. I'm sorry, if I may, Your Honor, a judgment...
The definition of a valid lien in the statute is a lien that's effective against the holder of a judicial lien subsequently obtained by legal or equitable process. Is this not effective against the holder because the holder holds the lien? Is that your argument, or is that Judge Duddy's argument?
That's a part of it, Your Honor, but if I may continue. Even if all of those tricks are successful, when did the lien lose its power to collect? Because I would say to you that Mary Wolfson, in the unlikely event she is deemed to be owning this thing, and no one will be more surprised than she owns it subject to the lien. And if there's a distribution that is now going to be ticketed to her, Olson owns it because the Illinois foreclosure says so. And not only do they want to use the lien to defeat the fraudulent transfer action, they then want to turn around and say, and it's no good anymore because Chris Coggeshall said or implied, and I don't accuse Chris Coggeshall of anything, they do, that Chris Coggeshall wasn't really going to use it. Therefore, when Mary Wolfson gets the millions of dollars in the future, Richard Olson is shut out because the same lien that defeated his fraudulent transfer case has absolutely no value or utility when the time comes to employ it. This is magical thinking. You can't get all of those places at the same time.
When someone files a complaint seeking money damages, don't they get a jury trial?
Well, Your Honor, that is not as easy a question as your question implies.
Well, that's why I asked it like that.
It's, in the case that Justice Murphy relied on, there was, as here, a tacked-on demand for damages on a fundamentally equity case. And as Your Honor well knows, the Chancery Court would award damages under the cleanup doctrine, even under a purely equitable matter when it was appropriate. And the central point of this case from start to finish has either been a determination that never happened to transfer, or that if a transfer happened, it was a juridical or legal nullity because of the technicalities. Or if that's not the case, and it actually was a transfer, the rights of the trustee to enforce the foreclosed charging orders have not somehow or other been defeated by all of this. But on the jury trial issue, the very case they cite in the Supreme Court of the United States, which, as we all know, doesn't control here because we're a primacy state. But in that case, the language upon which Justice Brennan's opinion relies says that when you're dealing with intangible property and equitable remedies, of course you do not have a jury, because at common law, Trover and Replevin would have been available for tangible property. Money hadn't received would have been available, as in that case, for money. But when it's not tangible property, and when it's not money, when it's an intangible, potential, contingent, unliquidated interest, especially in a partnership, partnership accounting is intrinsically an equitable matter.
Well, that's an interesting argument, given the language of Section 20 that says not only in all civil suits, but in all controversies concerning property, the party shall have a right to trial by jury unless it is otherwise heretofore been practiced. But isn't that a little bit different then with the analysis then of the Supreme Court and with the analysis that you just put forward about property not being subject to a jury trial?
Well, I don't know that any Maine court has yet said that every case gets a jury trial, because whatever the remedy being sought, whatever the nature of the property interest, the word property trumps all, and every single property dispute.
So what do you make of that language then, in all civil suits and in all controversies concerning property?
I think that the real point of it likely was, and this is, I guess, semi-informed speculation, that starting with the Statute of 13 Elizabeth in 1571, most often it involved conveyances of real estate. And most often, if not always, they were dealt with in equity or chancery court. But when you get down to it's about property, if we're talking about an antique automobile, then there's an action at law in Replevin or Trover over that property. But where the property is intangible, there is no action at law that can deal with it. And that's why there's no jury. As I've suggested.
Well, there's also a wrinkle in that our statute for the Uniform Fraudulent Transfer Act lets you have damages. So don't we have to look at whether the inclusion of that damage or ability to recover affects whether you get a right to jury under the statute?
Anytime there's a potential for damages, the subsidiary question or the next question becomes, what's the predominant thing here? And the predominant thing here is what Judge Studdy did, which from the beginning, before the beginning of trial, there was no mention of damages. Not even in the discovery, there's no mention of damages. It's a single word, and it'd be the height of formalism to take that single word and say that everything else about 400 years of history doesn't matter in the sorting. The fact is that fraudulent transfer actions are jury or not is still the law, and this case is like that one.
Thank you, counsel.
Thank you, Your Honor.
Attorney Campbell, you've reserved a couple minutes for rebuttal.
First, in regard to this issue about whether a wall of debt is some sort of nefarious thing, Mr. Olson himself, and I've cited this in my briefs, he testified that this is a standard advice that is given to people in commercial field, and he's in the commercial field, as in the same advice that Carl and Pam received, which was, if you're settling debts, and Carl was settling other debts, he was paying people money, you don't just wipe out the debt, you purchase the debt and you use it in the future legitimately to block other creditors. It's a recognized method. It's not fraud. Sounds like fraud maybe, but it's not. It's a recognized method, even according to Mr. Olson himself. So it was used here, and Carl did not embezzle money from the trust. Carl was managing the trust. He put up his own. I've cited, of course, all of the transcript in regard to this. He put up his own inheritance for these projects in Chicago, and he didn't embezzle it. What really the truth is that they decided to use that. Chris Cogshaw has to use that as a legitimate method.
Is there anything in writing on this?
There is a transcript of.
No, in writing at the time.
In writing.
In fact, you say in your counterclaim at paragraph 62 that the Promenade Trust's trustee urged that none of the real agreement be placed in writing because of possible creditor repercussions if the real understanding between the parties were obtained. What does that mean?
Well, I think that means that was a testimony. That means that creditors might see that as a method of attacking the transfer.
On what ground?
Attacking it as claiming it's a fraudulent transfer, but that doesn't mean that they'd succeed. That would mean to avoid that. I think that was the advice that he was getting. And so what they did was they structured it the way they structured it. The important point is this transfer happened in 2012.
Does that matter for the fraudulent?
Yeah.
Does that matter in terms of the of Section 3575?
I think 100%. The question of the fraudulent transfer statute is, what was the possible available equity to unsecured creditors at the time of the transfer involved? That's all that statute cares about. Was there equity there that somebody, other creditor, could have come in and gotten, that equity was taken away? If there was no equity there, which there wasn't here, then there's no harm, no foul. And there's dozens of cases from this court and the First Circuit and all of them saying if there's no equity in the product involved, and these GP
counsel.
interests.
Sorry. We are over.
Thank you.
Unless Justice Douglas has another question. Okay. With that, then, we will take the matter under advisement, issue a written decision in due course, and be in recess on this case. And you may be seated. And the matter before the court is Somerset 24-325, State of Maine versus Raymond Ellis Jr. We are being streamed live on the web, both by audio and by video. I would ask counsel to introduce yourselves by saying your names for the record, together with the party you represent.
I'll start. The appellant, Rory McNamara for Raymond Ellis.
For the appellee, Your Honor, Francis Griffin.
Thank you. And Mr. McNamara, if you are ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. May it please the court, counselor. A criminal defendant has a constitutional right to argue that when the state fails to call the sole human witness to testify, well, jurors should presume that person would have exculpated.
Can I ask you, I know I understand the argument that you're making, and I don't think you protected any time, so.
That's right.
Although the light isn't on.
Please.
I can see it.
It is now.
Are there any cases saying that as a matter of constitutional law, you have the right to have that instruction?
No, I don't think so. I
Okay.
think there are cases that say, well, at common law, this is something that we did. We
It
had
is.
this.
Is there a difference between an affirmative instruction saying you may infer that this witness would have been adverse to their case versus simply leaving it, if you will, almost as, you get to argue the holes in the state case, and that's just all there is to it?
Yeah, I mean, there is conceptually a difference. In this case, there's probably no difference because the judge shut down inquiry, well, not inquiry, but the argument into that area by saying, I'm going to deny that instruction.
The judge said he was going to deny that instruction, but that doesn't mean that the defense counsel couldn't have argued holes in the state's case, including the fact that we didn't hear from the key witness, and no argument was made, so there was no objection made, so.
Well, I disagree, Your Honor. There was also a no inference instruction given, and that instruction quite clearly said you can't consider the fact that other witnesses were not called and what those other witnesses might have said. You are to draw no inferences from the fact that they didn't testify and they weren't called. So I do think that in this case shut down inquiry. Now, back to your original question, is it possible to have in a different set of cases, a different set of facts where you're just not giving an affirmative instruction as to a missing witness instruction and there wouldn't have been prejudice? Yes, that's probably possible. But I do think the nature of that missing witness inference also coming from a judge is important. Many times defense attorneys are looking to sync up their arguments with what the judge is going to give.
Well, I understand that, but the question then becomes, is it constitutionally required to affirmatively give the missing witness instructions, or is it sufficient, maybe, and maybe even overkill, not to give the instruction that one cannot, speculate about a witness that didn't appear?
And I think my answer depends on which constitutional provision we're talking about. We're talking about two of them. Presumption of innocence on one hand, and if we're just talking about that, it's probably correct. I don't know of any case law that says otherwise, that it would be sufficient to just simply permit counsel to make arguments unfettered by instructions. However, if we're talking about the law of the land provision of Section 6, I think that case law and the interpretation of that, and certainly my argument is that requires an affirmative, where appropriate, affirmative missing witness inference.
Well, I guess that's where I really didn't follow your argument about why that provision, which is we have said is a stand-in for the due process clause for many years, how that under our state law requires that.
Much more than just saying it is a stand-in for due process. We have 150 years, the most recent case being in 1986.
So because the common law allowed it, then Section 6 says if it was allowed in the common law, it's now constitutionally required?
Right, that was the interpretation of this court through 1986. It is somewhat has fallen into desuetude, although certainly not affirmatively rejected, if you will. it has just, I think, gone the way of the dodo, as many things have in the past. We simply have forgotten what happened 150, 200 years ago, and have come to develop our own thoughts about what is appropriate. And but when you go back and look at the history of that, it was pretty clearly understood from the early days of this state that that provision means everything that was available at common law. So the maxims of common law. Even there's a case from 1853 that talks about whether or not when the state is pleading, they have to write Roman numerals, or they can write with alphanumeric letters, and that was something that this court considered under the law of the land provision way back in 1853. So that in order to run away from that common law is what is protected by the law of the land, this court would really have to erase a very long history.
So are you saying that you're making a Maine constitutional argument under the law of the land provision, and you're saying that there was a constitutional right to this instruction because you got such a right in 1820?
Or previously in Massachusetts and at common law, yes. Yes, that is the crux, and I believe that's the interpretation for, as I said, nearly 200 years of the law of the land provision in Section 6.
Well, there's evidentiary law, and then there's constitutional law. So you would have to argue that this evidentiary rule was embedded in the Constitution. And are you saying every rule of common law was embedded in the Constitution if that was the common law in 1820?
I think that's what this court has said. And it in fact said the Maine common law. And as previously, before 1820, the Massachusetts common law. And it distinguishes in several cases. We are not talking about English common law. We're not talking about those procedures and mechanisms and things, maxims, that were not introduced, they're not utilized in our common law. So it is a history that says exactly that.
Sometimes the Constitution embodies the common law, but sometimes it rejects what the common law was at the time. Isn't that correct?
It could, and I think that when you have a very specific provision of a constitution that's arguably at odds with what happened in the common law, then you would go to the specificity of a constitutional provision.
So originally, when the Constitution was adopted, for example, if I recall correctly, a defendant could not testify on his own behalf. So
Right.
Is that constitutionally required?
No, this court has interpreted since then that there is a constitutional right derived both in our state constitution, but also perhaps more importantly under the Supremacy Clause federally. So that is a more specific right.
Let me ask a practical question, if I may. If the missing witness inference is actually implemented, does that mean the state gets to call every person who was at the scene, every police officer who touched the case, no matter how cumulative their testimony is, just to negate the inference?
No, it does not. Now, just as...
Why not?
Well, they called, in this case, I believe it's 10 witnesses. So they called quite a few. To have one more, to have the sole victim, I don't think is a big ask for the state. But also at some point, even if it were possible under the standard, which I'll discuss in a minute, for a defendant to obtain a missing witness inference about the 15th, the 16th witness that the state could have called, at some point the state will say, what does it matter? I mean, it's ridiculous to ask for...
Does that mean that the defendant should be required to notify the state of its intent to argue a missing witness ahead of time so that the state can decide whether to call that witness?
I don't think that's been a requirement at common law. It's certainly not one that I'm aware of.
If not, then the state presumably gets to explain to the jury why it decided not to call the witness.
Well, I haven't thought about that, to be honest with you. when we look at I'm thinking about notice and demand statutes and with a confrontation clause, and the defendant would need to trigger those when they are implemented by the legislature. But those are in order to not waive a right.
Well, and part of the problem is you don't necessarily know as the defendant that they're not going to call a witness. Presumably, this person may have been listed on the witness list,
Right.
and you don't necessarily know until you get there that the person doesn't get called. So
And
it's a
that-
little hard to give.
I don't know if that was the case here.
Yeah.
I wasn't trial counsel. But I will say, I think perhaps the better answer that I should have given before going down this road is that the standard that is implicit and actually explicit in the missing witness inference instruction, the language, and there's a few different standards, are somebody that, so in other words, would be expected, might be expected, is somebody unnecessarily omitting somebody who you'd expect to offer. So if it's the 15th, the 16th witness, I think a judge could say at some point, within a judge's reasonable exercise of discretion, you don't get it.
Are you asking us to embrace the instruction that was requested here? I mean, the exact language of that particular instruction? It says the unexplained failure of a party to present an obvious witness to corroborate other evidence. Is that the language you want us to embrace?
That's what's preserved here.
Yes.
So that's what I have to give you. I have not done the research to know if there is a better standard, a more appropriate under the Maine Constitution
There's no
standard.
other state that says that there's a constitutional right under their constitution for an empty chair instruction, including Massachusetts, which says it isn't under constitutional dimension.
Well, I don't think most states or jurisdictions, including those across the street, have to say so.
But if your argument is we look at the common law of Massachusetts, Massachusetts is saying that was just an evidentiary rule. It wasn't of constitutional dimension.
Well, they also don't have the law of the land provision that we have and 200 years of interpreting it to mean the common law.
Can I ask you to be, are you suggesting the Constitution requires the instruction that Justice Meade or something like it was reading, or are you simply saying it requires defendants to be allowed to argue the inference?
Right. I think when we're talking about the law of the land clause,
Yes,
again,
that's my
distinct
question.
from presumption. Okay. So yes, I am saying that requires an affirmative instruction.
An affirmative instruction.
Yes.
So would you be concerned how this would play out in the context of, say, a domestic violence case, where sometimes a witness the state intends to call them, but they don't show up, and then what happens in that circumstance, and how does the state get to respond to what you're suggesting with the missing witness instruction?
Well, as is sometimes done, I'm thinking about cases where there is a late disclosure or something of that nature. The state often calls experts to say, well, here's why someone didn't testify or offer this information sooner. That's an available option, I suppose.
Well, and part
in
of it
those
is that the state
circumstances.
could have called it, isn't it? Isn't that part of the missing witness instruction?
Right, and I think that goes to the screening process that a judge should have some discretion over to say, well, is this appropriate instance here for the missing witness
Thank you. And
instruction?
I actually have more questions on sentencing, but we'll wait till rebuttal on that.
Thank you.
And Mr. Griffin, since you also didn't protect any time, I'll jump in on the sentencing
Excellent.
on this. This
Fair
issue
enough.
was not raised by Mr. McNamara, to my surprise. But in sentencing, the sentencing judge said that an aggravating factor to increase the maximum sentence in this case on the Huey analysis was a failure on the part of Mr. Ellis to take responsibility for his actions. What is the evidence of that? He didn't testify, he didn't allocute. Is there any evidence other than the fact that he had a trial?
No.
It's a problem, isn't it?
I think so. But I think when the court looks at the sentencing and the aggravating factors here, I would note that the trial court did specifically say that the defendant did not take the stand and did not lie, did not give any statements on a factual basis. But when you look at the sentencing, especially the aggravating factors, they far outweigh.
Well, they may, but we have said that when an impermissible factor is used, even if the sentence could have otherwise justified, that's a problem.
I acknowledge that, Your Honor. I think that the sentencing part that Mr. McNamara did raise was the brandishing of the firearm
I know.
versus being specifically armed with a firearm, and I do think that is absolutely permissible because there is a distinction to be made.
So you didn't prepare that specific issue for these arguments here today?
I did not. I, like Mr. McNamara, was not trial counsel. I am aware of this argument with other similar cases. I think Justice Stanfield and I have had this discussion before. But I do acknowledge that it is an issue, but I do note it's, I would say, harmless error in terms of.
Well, we have to use the obvious error, right?
That's true.
Because it wasn't preserved.
It wasn't preserved.
It wasn't.
Why wasn't this obvious error? Why was it not obvious error to identify this as a aggravating factor?
I don't.
And I don't mean to be, but I'm looking at State versus Moore from 2023, where we said that when a defendant's claim that a sentence has been increased because the exercise of right to trial goes to legality of the sentence, we review that constitutional de novo, and we go on to say that a sentence based in part on an impermissible consideration is not made proper simply because the sentencing judge considered other permissible factors as well.
I understand, Your Honor. I don't disagree with the court. I think when I have made this argument to the court, I have asked the court to consider that to not give the defendant a benefit of taking responsibility.
Clearly.
So I think you can flip that on its head. So it shouldn't be a mitigating factor. I do agree that it shouldn't be an aggravating factor for someone to exercise their constitutional
And clearly, if there's no evidence of remorse, then it's not a mitigating factor.
Yes.
And in Coleman, we talked about how, with allocution or testimony, then there may be a basis to say.
Yes, Your Honor.
Okay.
If you have any other questions, I'm happy to answer, but seeing none.
Well, talk about the.
Well,
I mean, could the defendant have argued that this witness, who is clearly in this case the obvious and
absolutely.
only uninterested, if you will, witness to the events?
fair.
Why couldn't the defendant argue that it seems at least strange? Maybe you can't speculate about what the witness would have said, but at least why isn't that witness here? He's the person who knows. And that's a hole in the state's case, just like a lousy investigation.
I think so too, Your Honor. But the really interesting part about this case specifically is there was a 911 call that came in that was the victim saying all of the things that trial counsel would have wanted on the record.
I understand that. That came in.
So I think that this particular case is unique in that while the witness was not called by either party, and either party could have subpoenaed the witness, neither did. I agree. It does create a bit of an issue. But allowing for commentary on that missing witness is what Brewer's all about. And that's what 40 years ago, this court overturned a case where a prosecutor said to a judge during a bench trial that there should be an inference made because the defendant didn't call.
But isn't there a difference between the defendant and the prosecution in these cases? I mean, the defendant does have the presumption of innocence, which and has no obligation to prove anything. So to say that the defendant should have called a witness is really starts to intrude on that issue, whereas this prosecution clearly has an obligation to fill the cup, if you will, and the defendant certainly is entitled to argue about missing pieces of evidence.
And I think that defense counsel did here in this case. There was discussion about DNA, there's discussion about fingerprints, there's discussion about alternative
Is
suspects.
part of the problem that the defense counsel didn't make any arguments that were objected to? In other words, maybe the defense counsel could have gone further in argument, but didn't try.
Perhaps. But I think defense counsel did an excellent job with what she had here. She made all of the right arguments in the correct way.
Is it okay for a defense counsel to argue to the jury, members of the jury, you've heard testimony from witnesses A, B, and C, but you didn't hear from D, who was right in the middle of this whole thing like there. What inference can you draw from that? Is that okay argument?
I think the state's position here, Your Honor, is that the jury should not be making any inferences, asking for speculation about what evidence would have been or could have been in evidence. The focus here, Your Honor, is that the evidence that has been submitted by both parties.
So how do you, I don't mean to interrupt you, but the example I floated to you, you said not like that. You're suggesting maybe there's a line that they can talk about something but not go beyond that line. How would we say that a defense counsel can point out holes in the state's case, including a key witness who was right there at the time, but they can't talk about that? What would be the rule of law that would give advice to defense counsel as to how far they can go with a hole in the state's case like that?
I think that here, talking about the deficiencies in the investigation, specifically with the detective, which was done, is as far as I think is permissible in this case.
Okay, so you think the argument should stay away from talking about holes in the state's case that involved a witness who wasn't called?
I do.
Okay.
I do.
Although technically speaking, in this case, you were referring to the 911 call that was played, I think, to refresh the detective's memory.
I think that is why it was played.
But technically, it came in not for the truth of the matter asserted. So the argument that was made was technically problematic and could have been objected to, right?
Yes.
Now, you're saying the defense should not be entitled to argue about what witnesses might have testified to had they been called.
Yes.
But it is all right for a defense counsel to point out that this witness wasn't called, this test wasn't done, et cetera, right?
How about if I just say, they didn't call Benito. We have to wonder why.
I still think we're talking...
Without trying to tell you what I think Benito would have said or to take an adverse
I still think... I think that's closer to fair game, Your Honor. It's not...
And if it's fair game, isn't that fair game undercut when you then give it, the judge not only doesn't give the missing witness inference instruction, but gives an affirmative instruction that one can't, speculate or think about what a witness who isn't here would have said?
Yes, it is. That specifically
in other words, should the court just be more neutral on that point?
They could be.
Does it really undercut, though? I mean, the jury could still, in its deliberations, say, hey, you know what, without saying what we think that witness would have said, the state didn't call that witness. That bothers me.
Perhaps. I think if that argument were to be made, I think that the instruction where the court is talking about not calling for the jury to not speculate what somebody would have said and why they weren't called, I think would be more important.
You've made reference to our examples here. That's fair game. That's not fair game. And that implies there's a line somewhere. What should we write in our decision if we adopt the point that would give guidance to our judges and to our counsel, saying this is how you define that line? You go over it. It's not fair game.
I think you can say that this is settled law, that the Brewer case and then the Russell case, in 23, establish what is or is not fair game.
Okay. All right. So just
Well, and that's kind of where I was going. So Russell didn't say, Russell said you didn't get an affirmative instruction on a bad investigation.
Right.
But in part of support of that, we said, and you were able to argue it.
Correct.
And that's a little bit of what I'm trying to get at here,
Right.
is it feels like maybe defense counsel felt constrained that they couldn't argue it.
But I think she did. I think she did, Your Honor. I think
Did
Perhaps
argue
on
it
the-
or did feel constrained?
that she did a good job arguing.
Did argue it, okay.
Yes, she specifically talked about, in her closing, she talked about the DNA, she talked about alternative suspects, I think named 2 or 3 individuals who were alternative suspects.
So it's talking about the investigation, but I'm saying the lack of Mr. Benito being there.
Yes.
I mean, that felt like defense counsel felt constrained that she couldn't argue about that.
I don't know, I haven't spoken to her about this case, but I think she may have.
And didn't, let me put it that way, didn't argue about that.
She didn't push the envelope here.
Seems to me that the prohibition on jury speculation about evidence benefits the defendant as much as it does the state. In other words, the jury is not supposed to speculate on why the defendant didn't take the witness stand and testify, or what the defendant might have said if the defendant had testified, or why the defendant didn't present any evidence.
And I think it probably benefits the defendant more, quite honestly, because of that presumption of innocence, because the fact that a defendant doesn't have to put on a case, they don't have to say anything, they don't have to do anything, and they shouldn't have to. And the jury should not speculate why the defendant didn't speak, why the defendant didn't put on a case, Your Honor. Thank you for your time.
Can I follow up on that, Mr. McNamara?
Yes,
Was there
please.
anything here that really prevented defense counsel from arguing more fully and pointing out that the state didn't call the most obvious neutral witness, Mr. Benito, and wondering, without trying to say he would have said X, that would clearly be improper, but, you know, one has to wonder why or what he would have said.
There was actually a very strange, I thought, exchange on the record with the judge saying to both attorneys, stay in your lane. I don't want any kind of misconduct in terms of the arguments here in this case. Defense attorney said, I feel like you're targeting me. So I do think in those cases that she was absolutely feeling targeted. And on top of that,
But
again,
if that's the problem, since she didn't make that argument, isn't that essentially,
Well-
we can't say that there was prejudice in terms of, she didn't try to make the argument?
I think she made the argument in asking for the instruction before the argument, and in objecting to the no inference, but perhaps even more importantly, that those were both indicia that she was really looking to make that argument.
Do you want to address the issue of sentencing about a failure on the part of Mr. Ellis to take responsibility
Yes.
being an aggravating factor?
I take responsibility. It's embarrassing for missing that.
That seems unlike the kind of thing you would miss, Mr. Mayor.
Well, thank you, and I did miss it. There's no strategy to not raising that. It is something that I simply missed, and I think the interpretation of Moore is absolutely correct. The court enumerated this as an aggravating factor. Some portion of his analysis, therefore, must depend on that improper factor. You know, there is a difference, I think, between knowing, and again, it was a great point by Your Honor, that 911 tape, that 4-second clip was offered, not for the truth, and being able to argue to a jury the fact that the state's sole eyewitness, disinterested eyewitness, and human victim didn't come to trial should mean affirmatively that he would have sat here had he testified and said, no, that is not the man who robbed me. And I think that that's the kind of argument, and I think there's a big difference between that and saying, well, there's a 4-second clip in the audio over there. But that's the kind of argument that should be allowed. It was also coupled with the no inference instruction simply confusing to hear, well, you can't speculate about what Mr. Benito would have said,
Well,
even though he...
And that's where I was saying, there's really 3 different components here. There's, do you have an affirmative instruction on a missing witness inference? Are you permitted to at least argue about whether, why, gee, it seems sort of odd that the state didn't call this guy, the one guy who we know, or, affirmatively instructing the jury that you can't speculate about what the person would have said. I mean, I don't know that it has to go one way or the other.
I think all three are permitted, certainly under the law of the land provision. Thank you.
Thank you. All right, thank you. Once more, we will take the matter under advisement, issue a written decision in due course. Thank you for your argument here this afternoon. And with that, I believe we are in recess for the day.